Good morning. This is Stephanie from the PUC. Mr. Barrett, can you hear me now? Looks like you're still muted, so you just have to unmute so you can speak. Mr. Barrett, if you can hear me, I sent you an email this morning about your exhibits that are in your box folder. If you can make sure to check that. Mr. Barrett, this is Stephanie. Can you hear me now?
Hello, can you hear me?
Oh, yes, I can. There you are.
Okay,
Perfect.
boom, I'm here. Ooh, thank God.
Yes. Okay. And then did you hear me that I sent you an email about your exhibits?
Yes, ma'am. I did.
Okay.
I'm trying to change that up right now to
Okay.
resend it. So, all you want me to do is just only do the exhibit part. So just page 10 to
Correct.
16
Yes,
and
yes.
then
So,
resubmit it.
but each page needs to be uploaded as its own document.
Okay, okay, one at a
Yeah.
time.
Yep. Because what you'll do is when you're going through your documents, you'll say, "Can we open hearing exhibit 100?" and I will pull it up for you. So it needs to be separated that way.
Okay. So let me just
Okay.
I got you. I know what to do. I'm recreating it right now. All right, let me
And then just so you know, this is all still recorded because it is after 8:30 and the live stream is going to be turned on in 1 minute. So I just want to make sure that we're not talking before the hearing starts.
okay, I'm gonna
Okay.
mute my microphone.
Okay, perfect. And then actually before I turn on the live stream, if you just want to test your camera real quick, just unmute or turn on your camera
Okay.
and then you can turn it right back off. I just want to
All
make
right,
sure
let
that the
me
camera works.
get back to where are we? Still trying to figure this thing
So
out.
on the Zoom session at the bottom, there's
Okay,
a
boom, I'm
video.
here. I'm here.
Oh, I just saw it flash, but I didn't see you. Oh, there you are. Perfect. Okay. And then you can mute yourself and turn off your video until the judge comes back on at 9.
Okay, cool.
Okay. Thank you.
And Mr. Barrett, if you would turn your background noise off also before the hearing.
Good morning, everyone. Ms. Kunkel, Ms. Boulay, are you both ready?
Yes, Judge.
Yes, Judge.
Thank you very much. My name is Aviv Segev. I'm the administrative law judge assigned to proceeding number 26F-0258EG. Today is Monday, August 31st, 2026. It is now 9:01, almost 01 a.m. This matter comes on for a hearing pursuant to the Commission's order setting hearing and notice of hearing in this matter and decision number R26-0487-I. I'm now calling the hearing to order. Mr. Barrett, it would be nice if you could turn your camera on. So we can all see one another. Until you may figure that out here, I can see you now. Great. Before we start with entries of appearance, I want to inform or remind the party that it is the Commission's practice to webcast legal proceedings and that both the audio and video feeds of this proceeding are being live streamed. We're also recording the hearing, and we have a court reporter who is transcribing everything that is being said. To avoid background noise, please keep your microphones muted until it is your turn to speak. When you speak, please speak loudly and clearly so we can get a good record. Because the hearing is being webcast, please avoid stating full account numbers or other sensitive information, identifiers on the public record. If an account needs to be distinguished from another account, please use only the last 4 digits unless I direct you to do otherwise. Let's start with entries of appearance. Mr. Barrett, I no longer see you on the screen. I assume you're still there?
Yes, I'm still here. I was told earlier that I had to update my documents. So that's
Right.
actually what I'm doing right now. I had to separate my exhibits from my actual hearing documents. So that's actually what I'm doing right now while I'm off screen.
Perfect. Let me please. Welcome first, and why won't you introduce yourself? Perhaps spell your name for the record, and in just a few moments, perhaps we'll take a short break, and then you'll have your documents in order, and we'll begin with the evidentiary portion of the hearing.
Okay, no problem.
Okay, so please introduce yourself.
Yes, my name is Reginald Barrett.
Very good. And you're representing yourself today, is that correct?
Correct, yes.
Very good. Mr. Smith, welcome. Please introduce yourself.
Thank you. Can you hear me? Everyone hear me okay? I just want to make sure my audio is all right. My name is Ross Smith. I'm principal attorney for Xcel Energy, and I'm on behalf of Piesco in this proceeding.
Thank you very much. I'll now briefly explain. Mr. Barrett, you'll have an opportunity to organize your exhibits. But so I ask that we all listen to a couple more instructions, and then we'll go on a break. So I'll briefly explain how this hearing will work. Since you, Mr. Barrett, filed the complaint in this case, you have the burden to prove your case. You will present the evidence first. You're welcome to testify and present documents as exhibits, which I know you already have, and we'll try to get in order pretty shortly here. You do not need to ask yourself questions. You may simply testify in narrative form. If you offered a document into evidence, I will give Public Service Company of Colorado, which we all here may refer to as respondent or public service or Xcel Energy. I'll give the company through Mr. Smith an opportunity to object. Mrs. Smith may object if there's a legal reason for why I should not admit the document into evidence. Once you, Mr. Barrett, have presented your evidence, it will be Public Service's turn to present its evidence. If public service offers document into evidence, I will give you, Mr. Barrett, the same opportunity to make legal objections to those documents. I may ask questions of some or all of the witnesses. That does not mean I'm taking sides. It is to make sure I fully understand the facts and the evidence in this proceeding. I will rule on exhibits and or an exhibit objection as they arise. If they arise, relevance will be the general starting point, and then concerns about reliability, accuracy, or other evidentiary issues may affect the admissibility and the weight of the evidence. I know we have one preliminary issue, which is the exhibits that Mr. Barrett is will be taken care of shortly. But let me ask you, Mr. Smith, do you have preliminary issues you'd like to discuss?
Just one, Your Honor, and this is, I want to first start by thanking Ms. Kunkel and Ms. Federico for discovering this. It appears that when we filed our exhibit list and with the hearing exhibits we intended to present this morning, we had the incorrect exhibit numbers on those. We have corrected those and put those in box, and I'm happy to, as we bring witnesses forward, to bring those forward for admission, but just wanted to clarify that.
Yeah, understood and appreciated, and I think so long as the documents that you wish to present as exhibits are identified correctly during the hearing today, I think we're good to go. I don't even think that there's a need to correct the filings in e-filings, though you're welcome to do so if you wish.
Thank you.
Mr. Let me see here. And any other preliminary matters other than the exhibits, Mr. Barrett? I'll ask you. Any other preliminary matter, Mr. Barrett?
Oh, no, not right now. Only thing I have to do is just separate my exhibits.
Okay, and Mr. Smith, no additional preliminary. Okay, very good. And so what we'll do is we'll take, Mr. Barrett, how long do you think you need to? I understand you need to do two things, or maybe three. Separate the documents into separate the exhibit. I think you filed one or you submitted one document through Box.
Yeah, I submitted.
So separate those into separate exhibits so that they can be easily identified. Then redact all of the instances where you know how to redact in PDF, meaning to cross out or blacken out your personal information.
No, I don't know how to do that. But
you don't know how to. Okay,
I could just cross it out, right? Just normally cross it out.
If you could do that, you could do it with a pen and then upload it. It might take a little longer. How long do you? And so and the third thing, I don't know. I had it in my head. I no longer remember. But I think if you separate the documents and cross out the personal information, such as your address and your the full account number, you may leave only the last four digits of the account, so we know how to refer to it. But the rest of it should probably be, because the reason I'm asking you to do that, Mr. Barrett, is because this hearing is public, so anybody can watch it now, and we'll be able to watch it later on the Commission's YouTube channel. So I don't want your personal information out there. So that's why I'm asking that you do that. So with all of that said, would a 15-minute break be sufficient, you think?
Yes, that should be great.
Okay, so it is almost 9:10 a.m. We will reconvene at 9:25 and by then I hope all the exhibits will be ready to go and we'll start the evidentiary portion of the hearing. So we'll be on recess until 9:25.
Okay, that should be enough time.
Thank you very much.
Yes, sir.
We are back on the record in proceeding number 26F-0258EG. Let me check with you, Mr. Barrett. Are you ready?
One minute, just 1 minute, only one.
All right.
I just gotta push one more PDF and that's it. I'm done.
Okay. Thank you. We can hold on for another minute or so.
Okay, I have all of them uploaded. And if
Okay.
there's an issue with the upload, the original upload has all the pages.
Okay. All right. So, all right.
I'm sorry, Judge. Can I interrupt before we're back on the record?
Of course, of course.
Mr. Barrett, I'm refreshing my screen. Did you label one as 102? I see 100, 101, 103, 104, 105, 106, but I don't see a 102. Or is that one still coming over?
Okay, hold on, let me look. Give me 1 second, I'm looking now.
Thanks.
All right, this one had to go on 2 pages. I guess that's why it didn't come again. Okay, yes, I think that one's in there now. And like I said earlier, though, all of them are in the same one, and the pages are loaded. So if what I just didn't work out right, we could just go back to the original, and I could tell y'all exactly what page we're on, and all the documents are already there. I was just told this morning that I had to separate them.
Okay.
Yes, I do see 102 now, so I see
Okay.
all those exhibits now.
Very well. Mr. Barrett, are you ready to present your case?
Yes.
Okay, would you please raise your right hand? You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Put your hand down and begin testifying when you're ready.
Okay. Your Honor, these proceedings involve unauthorized debt aggregation, deceptive billing manipulation, coerced payment, obstruction, and direct violation of the Colorado PUC billing standards by the Public Service Company of Colorado, aka Exhale Energy. The respondent violated state utility rules by reserving the inactive zero-out legacy debt and forging it into the complainant's active resident account without authorization. On dates May 28, 2028, the respondent manually forced a $2,330.44 balance from a closed inactive legacy debt onto the complainant's active residential account, despite the respondent's own accounting ledger certifying that the debt was written off to a zero balance on June 2nd, 2023, overriding the complainant's explicit refusal and providing zero satisfactory advance written notice. Respondent executed the transfer and caused an automatic system lockout that prevented the complainant from paying legitimate, undisputable charges from the current account. The complainant is respectively requesting a final order of the permanent decoupling of both accounts, complete removal of the $2,330.44 old balance from the legacy count, a full refund of bill credit of the $233 cash bond that I paid to come to court today, and the payment gateway normalized so I can use it properly, and a permanent bar against disconnection or collection against this disputed legacy debt.
I understand. I know you have exhibits to present, right?
Yes.
So would you like to go ahead and do that now, Mr. Barrett?
Yes. We'll just go in order. That way we can just stay with the order of everything.
And then we'll pause. And I don't believe you've removed the or you've redacted the documents. So
I didn't redact the new ones, the original old one. But I redacted the well, I'd never included. Well, no, I didn't even nah, I couldn't do that. I don't think so.
I'm just thinking what's the best way to present it without disclosing any of your personal information. Let me. I think what we might do, with your permission, Mr. Barrett, I will try to have my legal assistant, uh, just one moment. Okay, yeah, so that's what we'll do. Well, my very helpful legal assistant will redact each document and mark each document with the C. So that, again, so that your personal information does not appear on the public record. Do we have your permission for her to do that? It will take probably a minute or so before the presentation of each exhibit for her to do that. So again, do we have, and I see you nodding yes, and I appreciate it. But just so that we can get a good record, if you can verbally respond to my question.
Yes, you have my permission.
Thank you.
Okay, just give me a minute to do that, and then I will only show the public version with the redacted, but I'll keep his documents as the confidential documents.
Okay. Thank you.
Thank you.
Okay, so the document that I'm going to put on the screen is just going to be hearing exhibit 100, and then the document in his folder, I will remark as 100C, meaning the confidential version.
Perfect. Thank you very much. That would be great. So in a few moments, Mr. Barrett, you'll see the confidential version of hearing exhibit, what's been marked as hearing exhibit 100. And then you can, before I decide whether I admit each document, Mr. Barrett, I asked that you tell me a little bit about it, like who created it, how it was created, when it was created. And then, as I mentioned in the beginning, I will give Mr. Smith the opportunity to object if he wishes, and then make a decision as to whether the hearing exhibit will be admitted. So tell me about hearing what appears on the screen as and marked as hearing exhibit 100.
Okay. Hearing exhibit 100 is my billing account statements for both accounts before they forced the manual payment from 2023 onto the 2026 account. The first one that's highlighted in yellow is the current active account, and the one that is highlighted in white is the legacy account. And as you can see with the legacy account, you can see that it has a total of 0 balance on my account at the time that I took this screenshot, which was May 27th when I took this screenshot from the Excel Energy platform.
Okay, and I'll let you talk about this exhibit more if you wish. And then I see that there are a couple of paragraphs about the screenshot. That who authored them? Did you?
Yes, sir. I authored everything I have.
Okay, okay. So okay, Mr. Smith, any objection to what's been marked as hearing exhibit 100?
Yes, Your Honor. Well, I would first like to note that this is the first time the company is seeing these versions, although I understand that these were largely copied from the complainant's formal complaint. The other, and I think you've sort of alluded to it here, that the descriptors that are added here are subjective descriptors by the complainant, including what appears to be a legal conclusion regarding what is shown. So I would just note that I anticipate that you'll be able to use your judgment to afford it the way it's entitled to, but I would like to raise that objection.
Thank you, Mr. Smith. So I understand your uh, objection. I will give it the appropriate weight. What's been marked as hearing exhibit 100 is admitted. Mr. Barrett, anything else you'd like me to note about what's been marked as hearing exhibit 100?
No, pretty much everything that's on there is what it's about. That's the beginning of my account before any discrepancies happened.
Okay, all right. So understood. I then thank you, Mr. Barrett. I assume you want us to present now what's been marked as hearing exhibit 101. Is that correct?
Correct. We could go to the next.
Okay, so we'll we'll take a little bit of time to have Ms. Kunkel redact those, and then we'll present it on the screen just the same.
Okay, no problem.
Sorry, give me a second. I had the 100 public version that we just showed on my screen and I closed it without saving the changes. So I just need to save those changes really fast and move to 101.
Thank you. Mr. Barrett, do you see what's been marked as hearing exhibit 101 on the screen?
Yes, I do. I see it.
Okay, can you, again, before you tell me more specific details about the exhibit, tell me again what this document is, who authored it, and it looks like it contains a screenshot when it was taken from, and where it was taken from, and when it was taken.
Okay.
Please.
Okay. This screenshot is May 27th, 2026. This is the start of the dispute case. This is the very first text message of me telling Excel to not put these accounts together as one. I told them to manually unlink it. So this is the start of my dispute. This is the very first time I started the dispute. This is also before they made the manual transfer as well.
And Mr. Barrett, the portion that's above the section that's above the screenshot, that's all your writing. Is that correct?
Correct. Yeah. What that is I said on May 22nd, 27th, 2026, customer service interaction record. This transcript showing the creation of dispute case number 0661 demonstrates that Excel had full knowledge the merger was contested prior to forcing the charge overnight on May 28th.
Okay.
So this text message is 1 day prior to the actual reason why we're here.
Okay. Mr. Smith, I assume that this exhibit is subject to the same objection you had for what's been marked and admitted as hearing exhibit 100. Any additional objections, Mr. Smith?
No, Your Honor, just those same objections.
Thank you very much. Noted. Hearing exhibit 101 is admitted. Mr. Barrett, anything else you'd like me to note about what's been marked as and admitted as hearing exhibit 101?
No, that's fine. We could continue.
Thank you. I believe I said that hearing exhibit 101 is admitted, but if I didn't, it is. So now we'll go to hearing exhibit 102. And Ms. Kunkel will do again the same redaction exercise, and she'll present it on the screen as soon as she can.
Thank you.
Okay, Mr. Barrett, do you see what's been marked as hearing exhibit 102?
Yes.
Can you again, let's start with a short description of what this is. Again, I see a screenshot on the bottom portion and a narrative statement on the top portion of the exhibit. Can you tell us when it was authored, by whom, and when?
Okay, the two screenshots at the bottom are the emails between me and Excel on June 2nd, 2026 and June 12th, 2026. Pretty much the first one is where she's saying that they generated a balance, which means they created that pretty much out of thin air. So she admitted that they generated it. It was never actually moved or nothing. She says they generated that balance from an inactive account. That was the second one at the bottom. So what these emails actually are saying is that she admits that that her company or whatever, they created that balance and moved it. That's what these emails are saying.
Ms. Kunkel, I understand. Ms. Kunkel, if the second page has been redacted, can you please display it?
Actually, I just realized that there's 2 pages. Let me double check. Let me stop sharing before that.
Okay, thank you. I did not realize that either, so well.
Yeah, it was originally 1 page, but when I sent it to you the second time, the bottom email dropped down to the next page.
Yeah, there are account numbers on there, so let me redact that and I'll show you the second page.
Yeah, it looks like they are. So, thank you.
Okay, here's page 2 of that same document.
Thank you.
Yes, and that's the second email. Which
Okay.
is the first email was June 2nd, 2026, and the second email is June 12th, 2026.
Okay, so just to kind of recap what you just told me, Mr. Barrett. So this, what's been marked as hearing exhibit 101. Is it 101 or 2? I'm already confused.
We're on 102.
Well, I think it's 102. Yes.
Yes.
So what's been so there, it contains screenshots of 2 emails from June 2nd, and the second one is from June 12th. And it also contains, the top portion contains a narrative statement authored by you. Is that correct, Mr.
Correct.
Barrett? All right. Mr. Smith, same question regarding objection?
And that's correct, Your Honor. Same objection.
Okay, so Mr. Smith, objection is noted, and what's been marked as hearing exhibit 102 is admitted. Anything else, Mr. Barrett, you'd like me to note about what's been marked and admitted as hearing exhibit 102?
No, sir, we could continue.
I'm sorry?
And I said, no, we can continue.
Okay, very good. Now we'll, I think, do the same thing with what's been marked as hearing exhibit 103.
Your Honor, may I just have, I have one request just for the and I'm sorry, is it Ms. Kunkel who's
Yes,
doing
it is
the
Ms.
exhibits
Kunkel.
funds?
Yes.
If we could, it would be preferable for the and I should have noted this initially. I noticed that Ms. Good's contact information is on that email, and it's not that we have an issue with her being able to be contacted, but having that on the public record, we would just prefer if we could at least redact some of that.
Okay, I will.
Is that just on 102? I'm sorry.
I think it is. Sorry, go ahead, Mr. Smith. Can you answer Ms. Uncle's question?
I believe that's correct. It's on the emails that have her email signature. That's what we're referring to.
Mr. Barrett, do you have any objection to Mr. Smith's request?
No, sir, I do not.
Okay, so we won't do it right now for obvious reasons and to save everybody time. But the confidential version, I'm sorry, the public version of what's been marked and admitted as hearing exhibit 102 will remove the information of, again, who was that? Now I lost here.
Her name was.
It's Miss Ann Good.
Yes,
She's the
Miss
customer
Ann.
advocate.
Yeah, Ms. Ann Good's email and other perhaps personal information.
I see that. I found 3 email addresses and I'll redact them all.
Okay, very good. Again, we won't do it now, but the public version will be redacted to and not include her personal email account. So I think we're still working on hearing exhibit 103. And Ms. Kunkel will present it as soon as she's able to. Mr. Barrett, let's do the same thing. What this document that's been marked as hearing exhibit 103. What it depicts and who authored it, and what's the date it was authored, and again it includes a screenshot, so the date of the screenshot, and then I will ask Mr. Smith about his objections.
Okay,
Go ahead, Barrett.
this right here is from June 2nd, 2023 and May 28th, 2026. This is the legacy account write-off ledger. This is the ledger that's proven that the balance went to a 0 balance on June 2nd, 2023. And then it was also manually brought back on 3 years later on 5/28/2026. You can literally see it was manually put in. There was no balance on this count at the time. This came directly from Excel Energy. So this documents exactly the transfer from the legacy account.
And you say directly from Excel Energy, you went on the Excel Energy website, logged into your account and generated.
No, this came directly from Miss Ann Goody. She sent me this.
She sent that to you by mail, or how did she send it to you?
By email. She sent it to me. I took a screenshot of it to put it in the records to show exactly what the finances was at the time of transactions.
Was it attached to one of the prior 2 emails we saw in hearing what's been admitted as hearing exhibit 102?
It possibly could have been from one of those emails. Let me look at it. It's the one that she says she sent over the. Let's see.
Okay.
pretty much what it is she was sending over the account statements and ledgers from both accounts. So she sent me the account statement for account 1565 and for 0788.
Okay,
So pretty much this is the account from the legacy account, and it's actually showing exactly what happened with that account in these past 3 years.
okay. And you think it might have been attached to the June 12, 2026 email from Ann Good.
I believe so. Don't quote me on that. Hold on.
Was that the exhibit 102, page 2?
Yes, I
Yeah,
believe so.
102, page 2.
Yes, it is, because it says account histories have been provided for your review.
Okay, very
So
good.
yes, it comes from the June 12th, 2026 email.
Okay, Mr. Smith, any objection to what's been marked as hearing exhibit 103?
No, I would say if on the first page, I believe there's a descriptor there, just the same objection, but otherwise no objection.
Okay. What's been marked, thank you, Mr. Smith. What's been marked as hearing exhibit 103 is admitted. Anything additional you'd like me to note about hearing exhibit 103, Mr. Barrett?
No, sir, not at this time.
Okay, so we'll do again the same thing with hearing exhibit 104, the same thing. I mean, the redaction. It will take a moment for Ms. Kunkel to do that, and then we'll display it on the screen. Kunkel will. Okay, Mr. Barrett, do you see what's been marked as hearing exhibit 104 on the screen?
Yes, Your Honor, I do.
Again, can you tell me who authored it, when it was authored, where the screenshots the screenshot on the bottom of the first, I guess, and only page of this exhibit it was taken and when it was taken?
This screenshot is also along with the exhibit 103. This is the active accounts account statement. So the last one was the legacy, and this one right here is the active account. This came also from that email as well. This is showing the transaction history of this account from start to finish. It shows right here that on 5/28 that a manual balance was placed of $2,330.44. This is just shows proof of the transaction history for the active account.
Okay, and then again, the top portion of the screen that's not the screenshot was authored by you. Is that correct?
Yes, correct.
And I don't believe you mentioned, or you did mention. So it was you believe it was sent to you by Angud also in that same email from
Correct.
That's depicted in hearing exhibit 102.
Correct.
Okay.
Well, yes, correct.
All right, let me ask Mr. Smith. Mr. Smith, any objection to what's been marked as hearing exhibit 104?
Nope, I would just state the same objection, especially particularly regarding a legal conclusion. But other than that, no.
Understood. What's been marked as hearing exhibit 104 is admitted. Anything additional you'd like me to note about hearing exhibit 104, Mr. Barrett?
No, sir, we could continue.
Okay. We'll go ahead and have Ms. Kunkel redact hearing exhibit 105 to the extent it has personal information, and I think it might. Be another moment. Baird, you see what's been marked as hearing exhibit 105 on the screen?
Yes, sir, I do.
All right, so same drill, if you will. Tell me what this document is, who authored it, when the what appears to be a screenshot on the bottom of the exhibit was taken, and from where. Please proceed when you're ready.
Okay, this right here are the screenshots when I tried to make the payment on June 10th, 2026. With them doing that manual transfer and stuff into the account, it made my account invalid where I couldn't make a payment when my due date was there. These are the screenshots that I took of the app and the website that showed the 3 different discrepancies between the account. I guess that's why that happened. I don't know what happened or why it happened on their end. I just know that I couldn't make my payment when they did this manual balance transfer.
Okay, and then the top portion of the exhibit is your writing. Is that correct?
Correct.
And again, the bottom was taken you logged on to your Excel account online, tried to make a payment, and that's the once you attempted to pay, that's the screen that you saw. Is that correct?
Yes, those are the screens. And I also called, but I didn't have a recording of the call. But when I called, it said that my account was invalid and I could not make a payment. Because I tried on the app and the website first and it wouldn't go through. And then I tried when I called and they told me my account was invalid. Right after that, I had immediately emailed Ann Good. And the rebuttal to my email I sent her is the email from June 12th. Because this happened on June 10th. Then I emailed her and told her I couldn't make my payment for some reason. And the June 12th email is what she emailed me back.
Right. And then the screenshot was taken on June 10th.
June 10th.
Okay. Okay. All right. Mr. Smith, any objection to what's been marked as hearing exhibit 105?
Well, Your Honor, I would repeat my prior objection as well. I would also note that this one is a little different, and that's because I believe that what's being described here, I think that it's not necessarily, I think my issue is not necessarily with the description of what's been shown, but I think there's also a description added about this phone call and being blocked from payment on the phone portal. And I would say that, that really isn't relevant commentary to this specific document.
Understood. 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 It may not be, I'll
Of course.
regard it as Mr. Barrett's testimony.
Of course.
But I understand that.
Yes.
Things that may not be directly relevant to what's been marked as hearing exhibit 105 were included. I think they are, though, important for context. So again, I'll regard it as Mr. Barrett's testimony. My question, I understand that you have the same objection regarding the narrative statement on top.
Correct.
Any additional objection, Mr. Smith?
No, Your Honor.
Thank you. What's been marked as hearing exhibit 105 is admitted. Mr. Barrett, anything additional I should note about what's been admitted as hearing exhibit 105?
No, sir. We could continue.
Very well. I believe we have one last document that you wish to present as an exhibit, Mr. Barrett. Is that correct?
Correct.
Okay. Very well. So we'll give Ms. Kunkel a few moments here to make her the redactions.
Actually, Judge, I don't see any account numbers or addresses on this one.
I don't either. But let's just make sure. Hard. Yeah, I don't see. Mr. Barrett, since you have access to this document, do you believe that anything on it should be redacted?
No, sir. I think we could continue.
Okay, so let's just present what's been marked as hearing exhibit 106 on the screen. And you, Mr. Barrett, again, please tell me what this document is, what it contains, who authored it, when the screenshot was taken, and so on.
This document right here is the court bond compliance receipt that I received for this case. This is these payments right here are just confirming that I did make the payments that the court told me to make for the bond and to get back into my account. I'm actually back into my account. I can make a payment. I made the payment for the bond and I made a payment that I couldn't make earlier, the one that I had got blocked out a month ago. So and I made the monthly payment for that month as well. This is just showing you that I am in good standing and that I'm not trying to do anything crazy. I'm trying to make payments, but they're trying to, add a legacy account that actually don't exist no more to my account. But this is right here is showing that I have complied with the court.
And where was this screenshot on the bottom portion of what's been marked as hearing exhibit 106? Where was it taken? Where is it taken from?
This is taken from the Excel platform, and what it's showing is the payments that I made for the $335, which was the court deposit bond, and then that next month's payment, which was the 162.88. So it's
So
the
again-
bond of 233, it's the payment of the 102, and it's the payment of the 162.
Okay, and again, you logged on to your Excel account on your phone or on your computer, and looked at the payment history, and that's how you were able to generate this screenshot. Is that correct?
Correct.
Okay, and again, the top portion was authored by you. Is that correct?
Correct.
Last question, I think, regarding admissibility. When did you take that screenshot? Do you recall?
I took this screenshot after July 15th.
Sometime after July 15th.
Correct.
Okay. Mr. Smith, any objection to what's been marked as hearing exhibit 106?
No objection, and I would say no objection even based on what we've discussed prior.
Okay. Okay, very well. Thank you. Here, what's been marked as hearing exhibit 106 is admitted. Mr. Barrett, anything additional I should note about what's been admitted as hearing exhibit 106?
No, sir.
Okay. Let me see here. Mr. Barrett, do you have any additional documents you wish to present as evidence or additional testimony?
No, sir. Those was my exhibits right there. That was all of them.
Okay.
Judge, can I just ask a question quick?
Of course.
Is it okay, Mr. Barrett, that I change your exhibit numbers that you originally uploaded and put a C on the end of it to show that it is a confidential document?
Yes, that is fine.
Okay.
Thank you.
So what Ms. Kunkel just said is that all the ones that will be preceded by the letter C are the confidential versions and will include no redaction. So that they will be the exact same documents that you uploaded during the break at the beginning of this hearing. The public version of the same documents will include all the redactions that you have also seen when we presented each of the exhibits on the screen today. Okay. Let me see here. Mr. Smith, do you have any cross-examination questions for Mr. Barrett?
I do, Your Honor. I will say that I have like 2 questions, and I think so that should take, I would hope, less than 2 minutes.
Very well. So, Mr. Barrett, Mr. Smith will now ask you a couple of questions based on the testimony you just gave. When you're ready, please proceed, Mr. Smith.
Thank you, Your Honor. And good morning, Mr. Barrett. I don't think we've actually been introduced. My name is Ross Smith on behalf of the company. Like I said, I only have 2 questions, and I think that it'll just take a moment and I'll be done. And my first question for you, am I correct that you did not pay the $2,330.44 that was for what you call the legacy account? Is that correct?
No, it was written off.
Okay. And am I also correct that you did not pay the collections agency when that amount was sent to collections? Did you?
No,
Okay.
I just got the write-off.
Okay. And so just to make sure I'm clear, you did not pay that amount either when it was held by the company or by the collections agency that was authorized to collect on the company's behalf.
Correct.
Okay. I have no further questions. Thank you.
Thank you. I may have a question. I'll take a moment here, so just bear with me. Mr. Barrett, when you say that the debt was written off, what do you mean by that?
I mean by that, you could look on exhibit 103 and you can see the legacy account write-off ledger. And you can see on June 6th, June 2nd, 2023, that it says WO debtors unpaid amount written off, write-off. And it writes all the way off to a zero balance. My account was at a zero balance for 3 consecutive years.
Understood. Other than hearing exhibit 103, what is there any other document, statement, either verbal or in writing, regarding the amount being written off, the debt in connection with the legacy account, what you refer to as the legacy account having been written off? And I understand. I'm not saying that hearing exhibit 103 is not important or doesn't prove what you think it proves. I'm just asking if there's anything else other than hearing exhibit 103.
I kind of don't understand your question.
Okay, that's fair, because I probably did not ask it very well. So I hearing exhibit 103 shows, or at least purports to show, according to you, that the amounts owed by you in connection with the legacy account ending with 07888-0 have been written off. So I think I understand that part. Is there what other than what's shown on hearing exhibit 103? What else makes you think, if anything, and there may be nothing, that the amount associated with the legacy account ending with 0788 has been written off, other than hearing exhibit 103?
Exhibit 100 shows that it was a zero balance at the time.
Okay.
We're going on exhibits. That exhibit shows that pretty much, because those are the only two that actually show anything about that account, which was exhibit 100 and exhibit 103. Both of those showed the price, and the exhibit 100 showed that it was zero balance on May 27th.
Okay.
And exhibit 103 shows that it was zero balance on June 2nd, 2023.
Oh, very well.
For that time, the account was zeroed out. And with a zeroed out account, an internal write-off may adjust the balance sheets, but once the account is formally written off and adjusted to a certified zero balance, it is ceased to be active collectible asset under the utility tariff rules.
Okay. Understood. Has there been any statement by anybody at Excel, verbal or in writing, again, other than hearing exhibit 100 and 103, did anybody else mention to you that the amount has been written off?
No, and I never got an amount. I never got a official statement saying that they was going to try to transfer that written off of money either. So I was never notified that they was going to do that. Only thing I know is that the account was completely written off 3 years ago and brought back from the dead 3 years later. And that is considered unjust enrichment and improper double recovery.
When was the last time you attempted to make a payment?
I'm up to date right now. All my payments are current.
Okay. So you have been able to make the recent payments for recent.
Yes, ever since the judge told them to open my account.
Right. So ever since decision number R26-0435I, which prohibited the disconnection.
Correct.
Okay. Okay. Um, sorry, I may have one more question. I'm just bear with me.
No problem.
So what is the relief you're seeking? Well, just if you could just tell me in your own words, what would you like me to do?
Okay.
I
Give me one
understand that
second.
you believe you do not owe any funds in connection with the legacy, what you refer to as the legacy account.
Right.
So I assume you would like me to issue an order prohibiting the company from collecting the amounts due in connection with the legacy account. Is that all? And if not, what else are you asking me to do?
First, I would like for you to permanently decouple the two accounts so they could never be merged together again. I would like to have that $2,330.44 removed from my current account. I would like the bond restitution credit that I made either credited to my current account or refunded back to me in that amount of $233 that was the bond. I want the mandatory account normalization where I could get into my account so I could properly make my payments how I'm supposed to. And I want the permanent disconnection of the bar. The issue the permit order prohibiting the respondent from trying to collect on this debt anymore from the legacy account.
Okay. Okay. I think these are all of my questions, Mr. Barrett. Since do you have any additional testimony based on Mr. Smith or my questions?
No, sir.
Anything you'd like to correct or explain further?
No, everything's good.
Okay. And you have no additional evidence to present, is that correct?
Correct.
Okay. Well, then I thank you for your testimony, Mr. Barrett. It is now going to be the company's turn to present its evidence. Let me ask you this. Would anybody like to take a brief break, or are we all ready to go? That includes, my question also goes to my legal assistant and the court reporter. So if anybody wishes to take a short break, I'm more than happy to do that. Otherwise, we'll keep going. So I'll start with you, Mr. Barrett. Do you wish to take a short break right now?
I mean, I could continue, but if we could take a break, that's fine with me.
Okay. Mr. Smith.
Whatever your honor's preferences, we can take a break or we're fine to continue.
Okay. And Ms. Kunkel, Ms. Boulay, any requests?
Whatever the court's convenience is.
Okay, very good. I think we'll just go ahead and go on with the company's case. So, Mr. Smith, please, when you're ready, call your first witness.
Thank you, Your Honor. Public Service would call Robert Duenas to the stand.
All right, Mr. Duenas, do you mind turning on your camera? Maybe you already have. No, I don't see it yet.
Looks like it's coming. There we go.
Hello.
Hello, Mr. Duenas. Would you please raise your right hand? Do you swear or affirm that the testimony you're about to about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down, and Mr. Smith, you may continue with the questioning when you're ready.
Thank you, Your Honor. Mr. Duenas, could you please state and spell your name for the record?
Yes, sir. My name is Robert, Robert, Duenas, Duenes.
And I apologize for mispronouncing your name.
No, you're okay.
That's on me. And by whom are you employed and in what capacity?
I am the customer advocate supervisor for Xcel Energy.
Okay. And I believe before I make you available here, I think we have just a couple of exhibits we'd like to just sort of get onto the record if possible. So I think first, did you cause to be filed what's been marked as hearing exhibit 201 that I believe is in Public Services Box.com account? And that's your affidavit?
Yes, sir.
Okay. And could we please, we can bring that up just so we can, for completion of the record? And does this accurately reflect the content of the affidavit which you filed in this proceeding?
Yes, sir, it does.
Okay. And you've attested to it as accurate, but I'll just ask, do you have any corrections to make, or do you have any mistakes you'd like to identify for the record?
No, sir. I've reviewed it a couple times now, and everything is accurate to my recollection.
Okay. The company would move to have hearing exhibit 201 admitted into evidence.
Mr. Barrett, do you have any objection to what's been marked as hearing exhibit 201 into evidence?
Can you explain what is entitled in it?
That's what Mr. Smith just asked Mr. Duenas. It seems to be an affidavit, the affidavit of Mr. Duenas, so that's what it contains. Mr. Smith would like to present it to have me admitted as an exhibit in this proceeding. So my question to you, Mr. Barrett, is if you have any legal objection.
No, sir.
Okay, very well. So what's been marked as hearing exhibit 201 is admitted. Anything additional, Mr. Smith, I should note about what's been marked as hearing exhibit 201?
I would just ask that Mr. Duenas confirm that this affidavit contains your, I would say your recollection, but your recitation of the facts as to your testimony in this case?
Yes, sir, it does.
Okay, thank you. That's all I have to clarify on that, Your Honor.
Very good. And very briefly, Ms. Kunkel, if you can just scroll through, because I think there are 4 pages.
Sure.
Perfect. Yeah, we can do it pretty quickly. Just again, that's just to make sure we have all 4 pages, and all 4 pages are a part of the affidavit. That's it. So, Mr. Duenas, I'm assuming your question to Mr. Smith, earlier question about the accuracy remains the same. Is that correct?
Yes, Your Honor.
All right. Please proceed, Mr. Smith.
Yes, and Mr. Duenas, we in this affidavit, you also referenced 2 other exhibits, and so I'd like to go ahead and bring up one of those now. Hearing exhibit 203. It's in our box.com. And we can bring up the public for all of these. And do you recognize this, Mr. Duenas?
Yes, I do.
And could you just tell me briefly what this is that we're looking at?
This is a transcript of a call that occurred between Mr. Barrett and an Xcel Energy customer service representative.
Okay. And I believe am I correct that was referenced as a phone call you listened to a recorded phone call, and this is the transcript of that.
Yes, sir. That's correct. This call occurred on the 27th of May of 2026.
And so, having listened to both the phone call and reviewed this transcript, to your knowledge, is this an accurate representation of the contents of that audio phone call?
Yes, it is. I read through the transcript while playing the audio from the call, and it lines up pretty much exactly.
And I would just note for the record, too, that this is the public version that has redacted any of Mr. Barrett's personal information and account numbers and things of that nature. Is that correct?
That is correct.
Okay. With that, I would finally I would ask: is this the type of record that is normally kept in the ordinary course of business for the company? Is it not?
That is correct.
So with that, the company would move to have hearing exhibit 203, both the public and confidential versions, moved into the record.
The request is noted. Ms. Kunkel, do you mind quickly scrolling through the 7 pages? Again, it doesn't need to be super slow, just so that we're all on the same page and we know what's included in each of the 7 pages of this exhibit. As you are watching the documents being scrolled, Mr. Barrett, I'll ask you if you have any objection to what's been marked as hearing exhibit 203.
No, I don't have any objection with the call log. I was going to actually ask them for a copy of that call log.
Very well. So what's been marked as hearing exhibit 203 is admitted. Anything additional, Mr. Smith, I should note about hearing exhibit 203?
No, not regarding this exhibit, Your Honor.
Okay.
Finally, Mr. Duenas, you also referenced hearing exhibit 204. So if Ms. Kunkel, if we could bring that one up as well, that would be great. And I apologize, this one is going to be fairly unhelpful. This is heavily redacted to protect Mr. Barrett's confidential information. Without having to go into a confidential session, I would note that the confidential version does contain the figures here, and these are, I can have Mr. Duenas speak to that.
Yes, that's correct.
Okay, and I was going to ask Mr. Duenas, have you reviewed this document?
Yes, I have. These are taken from our internal customer service systems that we use to review and give out information to customers pertaining to billing and usage information and things of that nature.
I see. And having reviewed this and being familiar with the company's practice, is it in the ordinary course of business for the company to keep records of this nature?
Yes, sir, it is.
And as far as your review is concerned for this case, as far as you are aware, are these true and accurate representations of Mr. Barrett's account history?
Yes, sir, they are.
Thank you. With that, I would ask that hearing exhibit 204 and its confidential version be admitted onto the record.
Yeah, so I don't think we can. I can ask Mr. Barrett if he's if he has any objections, but he doesn't have. He cannot see any of the content. So
yes, and Your Honor, I would note that we did send these to Mr. Barrett on Friday as part of our disclosures. As far as I'm aware.
Okay, Mr.
By how?
By email.
From who? Because I never received anything from you.
I'll follow up with our internal staff and ensure that was done, but that should have been done at the time of filing. But I will double check on that.
Well, for the purpose of and I appreciate that, but for the purpose of this hearing, I wonder whether it would be best to go into a confidential session, or have you, Mr. Smith, send Mr. Barrett the unredacted version of this exhibit by email now.
Yes.
I think the second solution might be quicker.
Absolutely.
So are you able to have somebody email the non-confidential,
The-
the non-redacted version of what's been marked as hearing exhibit 204 to Mr. Barrett right now?
Absolutely. Absolutely. And Mr. Barrett, I believe I don't want to make you say your email here, but I assume that the email that has been used for this proceeding is the correct email that I could send this to.
Correct.
Okay,
I have it
I
open
will.
right now.
Okay, if I can have Your Honor maybe 2 to 3 minutes just to take care of that, we'll send that over now.
Okay, so well, let's just take up. Would a 5-minute recess be okay with everybody?
That would be great.
Yeah.
Okay, so during the recess, Mr. Smith, you'll cause this, and to the extent there are additional redacted documents, or
Of course.
at least heavily redacted documents. I mean, ones that redact the I'm sorry, the account number or Mr. Baird's address. Those are not an issue, but heavily redacted documents, to the extent they are such that you wish to present today, if you could send those to Mr. Email to those to Mr. Barrett as well, that would be great. So we'll take a 5-minute recess until, let's call it 10:49, and we'll reconvene then. We're on recess until 10:49. Thank you.
Thank you.
Thank you.
Thank you.
Okay, we are back on the record in proceeding number 26F-0258EG. Mr. Barrett, have you received the exhibit? What's been marked as hearing exhibit 200 and I believe it was 4? 204?
You are muted, Mr. Barrett.
Can you hear me?
Yes. now we
Okay,
can-
yes. I'm checking my emails right now. I do see a new email just came in from Ross Smith. Hearing exhibit. Looking at it now.
And again, I understand you may or may not agree with the content of the document, Mr. Barrett, but my question to you right now is whether you have a legal objection for why you should not.
No, I do not object.
Oh, okay. Very well. What's been marked as hearing exhibit 204 is admitted. And I know that it has a confidential and non-confidential and a public version, this hearing exhibit. Please proceed, Mr. Smith.
Thank you, Your Honor. And I believe that's all the exhibits that we have to admit for Mr. Duenas. And I would say that he is now available for cross-examination or for the ALJ's questions.
Very well. Mr. Baird, do you have any questions for Mr. Duenas based on his testimony today?
Not at the moment, I don't. I would like to look at what was admitted first and put that together. So at this moment, I have no questions for him at this time.
You will not get another opportunity to ask Mr. Duenas questions. This is I may ask him questions, but I'd like for you to ask Mr. Duenas questions. If you may not have any, but if you do, I think that may be your last opportunity to do so. Baird.
Yes, I'm listening. Give me a second. I'm looking over my documents to see if I have anything that might pertain to him that I might want to ask him.
Okay, of course. Take your time. Thank you.
And Mr. How you say your name? Mr. Robert, just to be respectful, I don't want to disrespect your
That's
last
fine.
name. My question for you is, can you explain to me what you actually do in your job?
So I'm the customer advocate supervisor. So the person you referenced earlier, Ann Good, is an employee of mine. So I supervise all the customer advocate analysts.
Okay. Speaking with Ann Good, when she sent me those documents and y'all seen that the balance was zero balance, why didn't y'all acknowledge that?
So based on the email that I saw that Ann provided you, she was acknowledging that what was referred to as the legacy debt had been transferred to the active. You know, when we're talking about accounts, we look at it in the guise of active and inactive. So if any information matches from an inactive account to an active account, then that's when we would adjust that debt, remove it from the inactive account and transfer it to the active account, which is what happened in this case.
But also, if you look at it, you see that the inactive account had a zero balance. So why did you not transfer the zero balance?
So the reason the inactive account had a zero balance was because the account had been transferred to a collection agency. Xcel Energy does not sell our debt. We assign the debt to the agency and the agency collects on our behalf. If and when a customer starts new service or an active account, then that debt is recalled from the collection agency and applied to the active account, which is what happened in this instance.
Okay, give me a second. I have another question for you. I have to find it. But also, the Colorado Pub Rule 3401 strictly prohibits balance transfers unless the utility issues an advance specific written disclosure itemizing the premises address, service dates, and the calculation before altering the bill.
Objection,
Do
Your
you
Honor.
have,
That calls for a legal conclusion from a witness who's a non-attorney.
excuse me, I didn't understand what you said.
I think you can rephrase your question, Mr. Barrett, in such a way that
I think I got my question.
that would not quote at least
Before I got my question. Prior to y'all adjusting the balance, did y'all send me, the complainant, any documentation that you was going to do that prior to doing that?
So, whenever services are stopped by a customer, you're provided a final bill which contains the remaining balance owed onto the account. After a certain period, if payment is not received in full, then it's referred to collections, and a letter is sent out stating that the letter has been forwarded to a collection agency company. Regarding whether or not notification is issued prior to recalling debt, that's outside of my area of expertise, so I couldn't speak to that.
Yes, that was the question I was asking. So you cannot answer about recalling debt. Is that what you're saying?
Well, no, I mean, I can tell you that, like I mentioned previously, that when an inactive account is sent to a collection agency and the person from that account begins a new active account, we recall the debt. But as far as whether or not you were provided notification, that's what I'm saying I can't speak to. Again, that's out of my area of expertise, so I don't know the particulars regarding what notices are sent out. But regarding the debt itself, at that point, when you began your new service, is when we initiated the process of recalling that debt from the collection agency.
Understand. So my question now is, you're saying that y'all are allowed to retrieve a dead ledger and hijack the active resident account without advance written notice because you don't know if y'all wrote it or not. And you're also saying that yeah, pretty much that's what you did. Y'all bypassed it. Now I have no further questions at this time right now.
Okay, thank you. I appreciate your question, your questions, Mr. Barrett. Bear with me for a moment. I may have a question for Mr. Duenas as well. Let me ask you this, and if you don't know the answer to that question, Mr. Duenas, that's fine. What, if anything, changed regarding Mr. Barrett's ability to access his Excel Energy account or pay his the charges, the Excel Energy charges, after decision number R26-0435-I was issued? And again, that decision is a decision that prohibit this disconnection. I believe it was issued by ALJ Farley. Do you know What changed,
Uh,
if anything?
No, Your Honor, I'm not sure. I haven't looked into that aspect. I can tell you that we offer our customers multiple ways of being able to make their payment. So that's one avenue that customers have, is to pay through the customer portal, either through the app or online. Mr. Barrett still would have had the ability to contact our customer care hotline and make a payment over the phone or pay through our website with a debit or credit card. Those, to my knowledge, were still available to him. But as far as specifically with the app itself, that I'm not sure.
Okay. Thank you. I appreciate the response.
I have some more questions if I may ask, but probably I don't know how this goes.
Yeah, I wouldn't normally. Mr. Smith, do you have an objection to Mr. Barrett's continuing his cross-examination now?
I would say as long as it's reasonable, that I have no objection to that.
So that's what we shall do then. Mr. Barrett, I'll allow you to ask your remaining questions.
Okay, my question is, looking at Exhibit 100 on June 2nd, 2023, did Excel Energy enter multiple lines titled WO Debtors Unpaid Amount Written Off on Legacy account?
I believe that might
true?
be 101
Yeah, that's
with
100.
the bill history.
Yeah. That's on 103. I'm sorry. Exhibit 103. I apologize. Wrong exhibit.
So Ms. Kunkel will present this exhibit, and Mr. Duenas, you can review it and then try to respond to Mr. Barrett's question.
Sure. Thank you, Your Honor. So these line items that you're referring to are how our internal customer service system shows that these balances are being removed when it's assigned to a collection agency. So for the purposes of the system, it automatically puts that line item as WO, or written off debtors, unpaid amount written. But that doesn't necessarily mean that the debt was sold off. That's just denoting that we're removing it from our system because it's being assigned to a collection agency. So, I guess to make a long answer longer, yes, it did appear on the date that you referenced.
Yes, and it did drop the balance down to 0 on the account. Is that correct?
Yes, again, because it was being removed from Excel Energy's internal system and being assigned to a collection agency. So at that point, when that transfer occurs, it does relegate the account in question to a 0 balance.
Okay. And between June 2nd, 2023 to May 27, 2026, did that legacy account reflect any active outstanding balance other than that 0 balance?
Because it had been sent to a collection agency, no, it only reflected the 0 balance until it was recalled when new service was initiated for the active account.
And you said we didn't provide no written notice. You don't know about that.
I'm sorry. I couldn't hear the question very well. I assume Mr. Duenas couldn't either. Can you repeat it?
No, I don't have any further questions right now. I'm sorry. I think I asked the questions I asked already. I think I'm asking the same questions over again with him.
Okay, all right. That's
and pretty much everything I'm asking him is already in my exhibits, and what he's confirming is already there. Okay. So he's pretty much just confirming what we already know. So it's pretty self-explanatory.
So I'll take another moment here and see if I have any questions for Mr. Duenas. And I'm sorry, just bear with me another moment.
No problem.
Think I don't have any additional questions. Any redirect, Mr. Smith?
Very briefly, Your Honor.
Please proceed.
Thank you. And thank you, Mr. Duenas. I just have a couple of redirect questions, if you don't mind. I want to sort of ask you just as a point of clarification regarding the write-off WO language. Is the way I understood your explanation that this is an accounting function, is it not? It's a function of the internal company accounting system?
Yes, sir. That's correct.
And just because it says written off, that wouldn't necessarily be the same as something being, as a debt being forgiven or discharged in some way, correct?
That's correct. That's the system acknowledging the transfer to the collection agency, so removing it from internal books. So it doesn't necessarily mean that the debt was sold or in any way no longer owed to the company.
Okay, thank you. And then I believe that, do you recall the ALJ Segev asking you about the technical issue regarding the issuance, after the issuance of his decision prohibiting disconnection? Do you recall that?
Yes, sir.
And are you aware, is it, within your scope of knowledge to know that whether or not that if a customer is in any sort of disconnection status or unpaid status, might that cause the mobile app to be somehow blocked or not allow payment? Is that something that could potentially happen?
Yes, sir. That's correct. I believe that's done in an effort to have the customer call into our customer service hotline so that way they can discuss options of payment arrangement and things of that nature to remove the disconnection notice.
And the intent of that, if I'm understanding you correctly, that's a company policy that's designed to prevent disconnection. Is that correct?
Yes, sir. That is
So
correct.
in other words, the idea is that the company is trying to ensure that the correct amount is paid or that a payment arrangement is made with the company to prevent disconnection. Is that correct?
Yes, sir. That is.
Okay. I have no further redirect. Thank you.
Thank you very much for your testimony, Mr. Duenas. I appreciate it. You may call your next witness, Mr. Smith.
Okay, we have just one more today. It should be brief. I'd like to call Mr. Jesse Anderson to the stand.
Right, Mr. Anderson, would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may put your hand down, and Mr. Smith, please proceed.
Thank you, and good morning, Mr. Anderson. Thank you for being with us today. Could you please state and spell your name for the record?
Jesse, Jesse, Anderson, Anderson.
And by whom are you employed and in what capacity?
I'm employed with Xcel Energy and the manager of customer contact center that helps oversee collection agency, third-party collection agencies.
And could you just explain just briefly sort of what that entails as part of I think that makes sense, but just if you could just expand a little on that.
Sure. We work with a set of collection agencies that collect debt on our behalf. So we work pretty closely with them in getting the debt over there, the records over there, on a case-by-case basis for customers that have gone delinquent with us and no longer have active service with us.
Thank you. And in anticipation of this hearing, is it my understanding that you prepared and caused to be filed what's been marked as hearing exhibit 202, and that's your affidavit?
Yes, that's correct.
And if we could bring that up on the screen, that would be great. And do you recognize this, Mr. Anderson?
Yes, I do.
And I'll just let us scroll through it there. And is it my understanding that this contains an affidavit supporting your testimony and the company's position in this case?
Yes, it does.
Okay. And to your knowledge, is it true and accurate to and based on the facts to the best of your knowledge?
Yes.
And do you have any corrections to make to it, or anything you'd like to, any errors you'd like to correct at this time? Oh,
Sorry. No, I do not.
well,
Were you able to hear my last response? No, I don't.
I apologize.
I was able to hear it.
Okay.
Can anyone hear me?
Yes, we can.
I apologize. It finally happened. My headphones actually ran out of battery in the middle of this. That has not happened to me before. Apologies to everyone.
Okay. Can you hear
And
you now?
I am sorry, Mr. Anderson. What was the last thing that you heard me say?
The last question that I heard you ask if there was any changes that I felt need to be made, and I answered no, there's not.
Okay. And do you have anything to add to this affidavit this morning? Oh, and I think you're muted now.
No, I do not. Sorry.
Okay, thank you. With that, the company would move to have hearing exhibit 202 moved into evidence.
Mr. Barrett, do you have any legal objections for hearing exhibit 202 being admitted into evidence?
No. I'm sorry, no.
Okay, so what's been marked as hearing exhibit 202 is admitted. Please proceed, Mr. Smith.
I am making Mr. Anderson available for cross-examination and/or the ALJ's questions.
Of course. Mr. Barrett, do you have any cross-examination questions for Mr. Anderson based on Mr. Anderson's testimony?
No, but yeah, I have my own questions for him. I don't have no crosses, but yeah, I do have questions for him.
Okay, so please go on.
Okay, when Excel, on what day did Excel refer or place the legacy account with your agency?
Typically, usually the debt is sent just prior to it being written off. Usually there's a time frame there where a collection notice is sent out to the last address that's on file for the customer's account. And then shortly after that time period, the debt falls through that process that was in one of the earlier exhibits of the internal kind of bookkeeping of reversing those amounts off there and allowing the collection agency to collect on our behalf.
Okay. And was that an assignment of collection only, or did the agency take ownership?
An assignment only. It's still our debt, and we can recall that debt if a customer becomes active again with us.
Did the agency return or close out this file when Excel returned the balance of collections on June 2nd, 2023?
You might need to ask that again, because I think I misunderstood the dates there.
Okay, did the collection agent return or close out this file when Excel recorded the balance as uncollectible on June 2nd, 2023, when it was a zero balance?
No, that's one that would have been with the collection agency to collect on their behalf. They wouldn't have closed it out on their end until the customer becomes active again, and we recall it from the whatever collection agency it's at, and then it becomes closed on their end.
And are you aware that the multiple write-offs did take the balance to $0?
From an internal balance sheet, we don't retain that debt on our balance sheet record. for a certain period of time, and then becomes showing as a zero balance, where the rest of that balance is with the collection agency, again, trying to collect on our behalf.
Is it true that this balance does not actively appear on the complainant's credit report?
It would not show on the credit report, correct?
Prior to May 28, 2026, did y'all send a formal written notice of debt validation directly to the complainant for the $2,333.44?
Not that I'm aware of, no.
Did the department or agency authorize Excel to bypass the standard collections procedures and execute a manual balance transfer directly onto the active residential account on May 28th, 2026?
No, I'm aware of that. We operate with the policies that we have.
Can your department produce any signed agreement or consent from the compliant agreeing to revive this legacy balance to the new residential contract?
No.
When Excel claimed the corporate write-off on June 2nd, 2023, did your agency or Excel classify this account as uncollectible bad debt loss?
Objection, Your Honor. I just would like to make a point of clarification that Mr. Anderson is an employee of Excel Energy. He is not an employee of the collections agency. I think there may be some confusion on that point, so I just wanted to clarify that. And that was all I wanted to raise.
Thank you, Mr. Barrett. Did you understand Mr. Smith's clarification?
Yeah, he works for Excel, right? And he's part of the collection department, right?
Right, and he does not work for the collection agencies. Yeah, I think, yeah, correct. So when you're, because I think
I'll revise the question a little bit.
It's okay. Thank you.
What I'm asking is, since you work for Excel, the collection agency, did y'all classify the account as uncollectible debt on June 2nd, 2023?
It becomes, from a bad debt bookkeeping standpoint, it's classified as uncollectible while it's at the collection agency, and they're trying to collect on our behalf.
Okay. Yeah, I don't have any more questions right now at this moment for him.
Thank you. As I mentioned with the prior witness, Mr. Barrett, you may not have an opportunity. I don't think you will have an opportunity to ask Mr. Anderson more questions. So if you can think of another question, I can give you another moment to think about it. You might do so now.
Okay. Are you familiar with unjust enrichment?
No, I'm not.
Okay. No, I'm not. I have no questions for him at the moment right now.
Okay, and I think I have one, Mr. Anderson. Are you aware of what notices, if any, were sent to Mr. Barrett in connection with three things: the debt owed in connection with his legacy, what's been termed as legacy account, the account ending with 0788-0. The account being the debt being transferred or assigned to a collection agency, or the reactivation, if you will, and perhaps I'm using this term incorrectly, of the old account, at least the debt from the old legacy account, the account ending with 7088, and associated with Mr. Barrett's current account, the account ending with 5156-5. So again, my question, I'm sorry, I spoke a lot, and I don't know that the beginning portion of of my question was registered, and not because anyway, were any notices sent of the three that I mentioned sent to? Do you know if they were sent to Mr. Barrett?
So I'll answer kind of from your most recent question, Your Honor, backwards, if that works. With the debt coming back on the account, I'm not aware of any notices that were sent to him prior to it coming back on the account. As far as it being sent to a collection agency, yes, that would have occurred in that 2023 timeframe. Prior to it being actually sent, there are notices sent to the last billing address on file that we have, letting them know that it's going to be sent to collections. And I apologize, Your Honor, I'm not quite sure I did understand the first part of the question.
The first part of the question is to note that the account is past due, and what the past due amount. I guess that's done automatically, because if a person, well, I'll just have you answer. So just to note that the account is past due, noting when the account first became past due, and continued to accumulate debt, where notices, I'm assuming billing statements were sent. So I think, well, I'll let you answer the question.
Yes, thank you for clarifying, Your Honor. Yes, prior to on the legacy account, there would have been billing statements, notices, potentially outbound automated calls to notify that the account was past due.
Okay. And that's your standard practice, right? Is that correct?
That's correct, Your Honor. Yes.
I have no further questions. Mr. Smith, do you have any redirect questioning for Mr. Anderson? Apologies.
Just a couple, Your Honor. They should only take a moment. Mr. Anderson, thank you for your testimony. Like I said, I just have a couple of questions to clarify the record. Not asking you to draw a legal conclusion, but are you aware in your professional position, are you aware of any requirement that a customer is required to be notified in advance before a debt is recalled?
No, I'm not aware of any such communication that needs to happen.
And again, I think I asked the same question to Mr. Duenas, but I wanted to make sure that I understand correctly. This write-off language that's included, that is he described that as a function of the company's accounting practices. Is that correct?
Yes, that's correct.
And it does not, but that doesn't mean that the debt's been forgiven or somehow discharged.
That's correct.
Okay. And then I believe Mr. Barrett asked you a question about his credit report. Could you briefly explain why that would not appear on a customer's credit report?
Yes, we don't house internal Social Security numbers, which is typically something that collection agencies need to report to the credit bureaus. So they don't get a full Social Security number. They may get a last four. So they don't report to credit bureaus on our behalf because of that. So it won't show up on there.
Okay. So again, that's a function of sort of this being sort of a slightly different type of debt than maybe would be normally understood in a collection situation. Is that correct?
Yes, correct.
Okay. I believe that is all of my questions.
Have you presented all the evidence? I'll get to you, Mr. Barrett, just one moment. Mr. Smith, did you present all the evidence you wish to present today?
I have, Your Honor. Thank you.
Mr. Barrett, I saw your hand up, and I wanted to ask you if you
continue. No worries.
I'm sorry?
I said, no worries about my hand. We could just continue.
All right. So let me just ask you this. Do you have any rebuttal, any evidence you wish to present that might contradict the evidence or might go against the evidence that was presented by the company, by Excel?
Pretty much like I have some statutes that says that they have to notify me. I got other statutes saying that they did a bait and switch because I was not notified about that when I created my account, or the few months that I had my new account. They just manually did it. There's a statutes against that.
Okay, I'll just.
Yeah, because there's a proper procedure that they were supposed to do, and they didn't do that. No way, shape, or form. They didn't. They violated a lot of the CCR rules.
Okay. Do you know what specific rule they might have?
We have regulated rule 4 CCR 723-3-3401, and that's billing accuracy and transparency. Utility records must reflect true net amount due. They put a $2,300 amount balance on an account that was a 0 balance, and the other account was a 102 balance.
I see. I understand your claim with respect to this. Any other rule you believe that?
Yeah, we got the brief for contracts and the tariff terms. Also the mandatory statutory advanced written disclosure. Yeah, we did that one. Reviving account processes. Reviving an account process as uncollectible losses on June 2nd, 2023 is improper double recovery and unjust enrichment. Also CRS 6-1-105, Colorado Consumer Protection Act, deceptive, what I said about the deceptive bait and switch billing. When my bill was 102, then it went to 23. The one and protect. Okay, no. Yeah, the main ones I got is
I'll just mention to you, Mr. Barrett, that this is a hearing that is taking place at the Colorado Public Utilities Commission, and as such, I have authority. My authority is limited to Title 40, which includes, by the way, the rule that you noted, as well as other rules, and again, all the provisions within the Title 40 in the Colorado Revised Statute, as well as the tariff, the applicable tariff under which Excel Energy operates. So claims for such as unjust enrichment might be outside of my jurisdiction. So again, this is not a court of general jurisdiction, and not all claims can be made here. So I'll just say that I think I wanted to see if either one of you had a desire to make a closing statement. I think you kind of did, Mr. Barrett, but if you wish to expand upon it, I'll give you the opportunity to do so. Then I'll give Mr. Smith the same opportunity to make a closing statement. So I think the way you tied it at the end to the rules and statutory provision, it made sense to me, at least, your claims. But if you wish to expand on that, please go ahead, Mr. Barrett.
Yeah, pretty much. My closing arguments was what I told you earlier. What they did was unjust, but the permanent, I would like to have this permanently decouped off my account. The balance removal, the bond restitution back, and my account back to normal, and the permanent disconnection of this bill from my accounts. That's what I'm asking to have happen. And with my closing arguments, pretty much, yeah, that's what I got. Yeah. So pretty much is like what I said in the beginning, that these proceedings involve unauthorized debt aggregation, deceptive billing manipulation, and coercive payment obstruction. And like I said, that's a direct violation of the Colorado PUC billing standards. Yeah, because
Okay.
yeah, I respectfully request that those 5 things happen.
All right. I noted your requests. I will give now. Is there anything else, Mr. Barrett?
No, everything I have is pretty much in the first document I sent you, pages 1 through 16.
Okay. Very well. And which are the same exhibits that were which contain the exhibits that were admitted into evidence today. Is that correct?
Right, the exhibits, and then the master hearing brief evidence packet, which is where all of it put together.
Well, I can consider something that wasn't presented as evidence here in this case, but I think your testimony, together with all of the exhibits, covers. I think it covers everything you intended to cover. Is that not the case, Mr. Barrett?
Yeah, I think so, because pretty much I wanted to give you the what we didn't send, because it was 16 pages total, but I actually only sent you the last 7 pages, which was the exhibits. So the rest of it was pretty much my chronological statement facts.
But I think you probably covered it in your open statement / testimony portion. Is that not correct?
Yeah, yes, that's correct. Yeah, we
Right.
pretty much
So that's
went
a part
over
of the
everything.
record now.
Yes, we went over everything pretty much verbally. That
Right.
was in the first 9 pages that I sent you earlier today.
Okay, very well. So that means it's a part of the record now, because you communicated this during the hearing, and so it's a part of the record, and I will consider it as a part of the evidence in this case before I issue a recommended decision. Anything else, Mr. Barrett?
No, sir.
Mr. Smith, would you like to make a closing statement?
Yes, Your Honor. If I may, I think
Of
that would be beneficial here. And I can begin if you're ready.
Ready. Thank you.
Thank you, Your Honor, and thank you, Mr. Barrett, for attending today and presenting your case. I think it's important to start by restating the purpose of the hearing this morning, and namely that's to adjudicate whether the complainant has or can demonstrate that the company has violated any tariff, commission rule, or statute. I think after presentation of evidence, after everything that's been filed in this case, Mr. Barrett has not and cannot do so. Instead, he has alleged that by attempting to collect on an unpaid debt that he himself has admitted to not paying, that the company is being fundamentally unfair or improper. As the company has maintained throughout this case, and as it's been supported by requisite record evidence, the company has properly attempted to ensure that customers who do not pay their bills, even when the unpaid amount is sent to a collections agency, and when the customer then opens an account at a new address or attempts to open a new account, that customer is still held accountable for non-payment. This is not punitive. It's an attempt to ensure fairness by enforcing financial obligations incurred by those who benefited from service. As to the issue regarding linked accounts, there is no requirement or need for permission that the company is aware of or that has been demonstrated that requires permission before a balance transfer can occur. I would note that Mr. Barrett points to Rule 3401, which I believe he's referring to 3401D of the Commission's rules. I will note that the text of that rule requires the company inform the customer of the amount and the source of the amount. It does not require the company to seek or obtain the customer's permission before doing so, and it also does not require that notice be given in advance of doing so. As far as the company is concerned, the company has met its obligation to do so by informing Mr. Barrett, including by doing so on the written statement which he received. This was done on numerous occasions, including in the communications that Mr. Barrett himself points to for evidence. So the facts, I think, of that situation is Mr. Barrett was the customer of record on the prior and the current accounts. The unpaid balance remained from the prior account and remained due after collection efforts were unsuccessful, even by the collections agency authorized to do so. The balance was then transferred after Mr. Barrett attempted to open a new account, and the transfer was performed pursuant to all approved tariffs and company procedures. As to Mr. Barrett's invocation of CRS 61105, that's the Colorado Consumer Protection Act. ALJ, I believe you've correctly noted that relief may be outside the bounds of this proceeding, but I will note that the conduct challenge has not been necessarily challenged with any specificity here, and none of the company's actions were demonstrated to be non-compliant. In addition, the company denies entirely any allegation that it's engaged in any false representation or deceptive practice. And finally, the company would note that the complainant has not established any of the elements of a private CCPA claim, including the prongs of deceptive trade practice or demonstrated public impact. And finally, as you noted, claims regarding unjust enrichment and breach of contract are outside the scope of relief that could be granted. Point in fact, there is no coupling of the accounts. We're talking about a balance transfer. The accounts were not coupled in any way, so that relief is not something that really could even be granted, even if there were merit to that claim. And just as a final closing note, for our purposes here, the complainant has not, by his formal complaint or by any evidence presented today, in any way demonstrated that the company has been non-compliant with any tariff, commission rule, or statute. Accordingly, the company continues to argue that the proper relief is that the formal complaint be denied and dismissed with prejudice. I will note that the company agrees that this situation is unfortunate and that the complainant may disagree with the company's billing practices or the way in which it deals with its unpaid debt or the way in which it works with collections agencies. We understand that. We have taken that into consideration as part of this complaint. This has brought this to our attention, and we're always working to better our relationships with our customers, and we're going to learn from this situation as we evaluate what works and what doesn't and implement as many customer-friendly billing and programming interfaces as we possibly can. So with that, I have nothing further to add. I thank you for your time, Mr. Barrett. I thank you for your time, and obviously for all of the commission staff who have made their time available. I appreciate their time as well. So thank you.
Thank you very much, Mr. Barrett, Mr. Smith, Mr. Duenas, Mr. Anderson, for your presentations and testimony. I will take this matter under advisement and issue a written recommended decision. Any last second questions or comments? Hearing none.
One thing, Your Honor, I would ask, I assume that this was, the closing statements were in lieu of a statement of position. Is that correct?
That's correct.
Thank you.
Yes. They will not be, I'm stating it for the sake of the record and so that Mr. Barrett understand there's no requirement to submit. And in fact, I would urge you not to submit closing statements of position as I have just heard both of you. And I think the issues have been well addressed during the hearing. And so I don't think there's a need for it. So as I said, I will take this matter under advisement and issue a written recommended decision. And with that, thank you again, and we are adjourned.
Thank you, Your Honor.
Thank you.